Well, it's my pleasure to be here today at the Law and Mental Health Conference to give a historical account of how Washington's sex offender commitment law, the so-called sexually violent predator law, was put into place and what happened to it when we tried to stop it. Before the Supreme Court ruled on it, we had a series of articles in the Seattle University School of Law review, including one of mine at the very bottom, and one from a friend of mine, colleague John LaFond, in what he called a deliberate misuse of the therapeutic state. This was mine, Nightmare in the Halls of Justice, inspired by Kafka's The Trial, because these clients who were prosecuted had done nothing new wrong. They had been punished for their crimes, and in one case, Mr. Cunningham was out in the community for several months, and the other, Mr. Young, was going to be released from prison the next day. These cases show that one or two judges can make a huge difference. When we went to the Washington Supreme Court, the court decided in a 6-3 decision, I think one that surprised even the prosecutors, that the sex predator law was constitutional. They reversed Mr. Cunningham's commitment because they did several things to find that the law was constitutional. One of them was to require a recent overt act if you had been in the community, which was something that normally is considered in a civil commitment law. They said that that did not apply to Mr. Young because he was in prison. The court described the Community Protection Act as responding to citizens' concerns. This was definitely the case. It was like a railroad train running through the legislature at that time, and there just was not any real opportunity for people to think about the long-term consequences for a justice system of locking people up who had not done anything new. This U.S. Supreme Court had said that to be locked up in a civil commitment, you had to be mentally ill and dangerous. The Washington court said this was just fine because mental abnormality covered a large variety of disorders, and that there were mental health professionals who said that was just fine with them. We had mental health professionals who said this is bogus, but we didn't win. And they said no recent overt act is needed if you're in prison, but if you're out in the community, then there needs to be proof of recent overt act. And since there wasn't, they reversed Mr. Cunningham's case. And also, Mr. Cunningham had a non-unanimous jury, and the court found that that was a requirement as well. The court also said, you know, it's a problem under this statute that there's an initial probable cause determination without an opportunity for a hearing, and that's terrible. There's a risk of wrongful detention. But it didn't happen in these cases, so it's harmless. But from now on, it has to happen. But since these guys were convicted at trial, too bad. It's not a problem for them. We also said, hey, you know, there's an equal protection right to consider less restrictive alternatives to confinement, and that's what our regular civil commitment statute does. And the court said, hey, yeah, you know, that's right. And so we're going to reverse Mr. Young's conviction just to remand on the consideration of less restrictive alternatives. He's still a sex predator, but he can consider alternatives to confinement. And there has to be a 12-person unanimous jury. Again, the court just added this into the statute on its own. by saying that proof beyond a reasonable doubt means a unanimous verdict. I think those are two different things, but the court said that they were the same. In Mr. Young's case, many years earlier, he had been a college student and convicted of a bomb threat on campus. This came into evidence against him at trial over our objection, and the Supreme Court of Washington said that was harmless too. Shouldn't have come in, but it was harmless. So they said that the statute was civil. This turned out to be a very crucial finding when the case went to the U.S. Supreme Court. And so there were no substantive due process concerns in the case. And there were these little problems like the 72 hours and so forth, but those are harmless. Mr. Cunningham was reversed, and the state never tried to prosecute him again. And although it took a week, we got him out of custody and he was able to go home. There was a strong dissent by Justice Johnson in the Washington Supreme Court. He basically said that indefinite commitment of people that are not mentally ill threatens all of our liberty, not just the people that are being prosecuted, and that's what this was, that these folks were not mentally ill, and this was a dangerousness court. And he said that this was a grave error in setting up special class of people that can have fewer rights, and that the statute was a preventive detention scheme based on allegations of future dangerousness. Signed that opinion. Had there been two more, the statute would have gone away. The way he described it, the statute authorizes holding someone forever for the good of the community based on one sexually motivated crime, no matter how long ago it was. And we would be better off by adhering to constitutional principles. He said that the statute is based on fears of future crimes, and it offends ex post facto law and double jeopardy law by masquerading as a civil commitment law when its purpose is penal. He called it punitive in purpose and effect. That phrase was very important as the case went forward in federal court as well. So then we filed a federal habeas corpus, and one of the great moments in my career was getting in a phone booth, finding out that the district court had found the statute to be unconstitutional because it violated everything we said it did: substantive due process, ex post facto, and double jeopardy. If a statute pretends to be civil, but it's criminal in purpose and effect, then as applied in this situation where the law was passed after Mr. Young was already in prison, punishing him again for what he did before is double jeopardy, and the statute is ex post facto. It's passed after the incident that led to him being locked up. But even though we won in federal habeas, the state appealed, and it went to the Ninth Circuit. But by the time the Ninth Circuit got to deal with it, the U.S. Supreme Court had decided a similar statute from Kansas in a case called Kansas versus Hendricks. And they said that the law was just fine. I did a friend of the court brief in that case, but didn't prevail. In this case, one judge made a difference. It was a 5-4 decision saying that the statute was okay. Justice Kennedy filed a concurrence, and Justice Breyer, Justice Stevens, Justice Souter, and Justice Ginsburg all dissented from the Supreme Court of the United States decision, saying that the Kansas law, which had mental abnormality as well, was just fine. Justice Kennedy said, let's be careful. If the civil system is used simply to impose punishment, then it's not performing its proper function. And we should bear in mind that this is a concern. He said that on the record we have, Kansas conforms to our precedents. But if civil confinement were to become a mechanism for retribution or general deterrence, or that mental abnormality is too imprecise a category, then it would not be okay. The dissent, led by Justice Breyer, and of course, you know, most of these justices are gone now, but and all of the dissent are gone. Inadequate treatment is what the issue was, both in our case and in Kansas, that we were saying, hey, these guys are basically in a prison and they're not getting treatment that even comes close to being real treatment. And so the dissent in Kansas said, then it's punishment, and you can't punish the person with a law that's passed after the act. So the Ninth Circuit, when it got our case back, said, well, you know, let's go back to district court. And we went to district court. We didn't get anywhere. We went back to the Ninth Circuit. And in the Ninth Circuit, we talked a lot about the treatment problem. There wasn't real treatment. When this law was passed, our clients were held in the prison in Monroe, just in a different part of the prison. They didn't even pretend that it was a treatment facility, really. They eventually moved them to McNeil Island, which was an even more remote prison. And so what the Court of Appeals in the Ninth Circuit said about our case is, if the petitioner, Mr. Young, can prove what he says about the punitive nature of his confinement, then the law does violate ex post facto and double jeopardy. So we're going to remand this to the district court to have a hearing on that. Well, we never had the hearing on that because, and they said it had to be by the clearest proof. And we never got the hearing because the state sought review in the U.S. Supreme Court, which granted it. And 8-1, we only got one justice, Justice Stevens. The U.S. Supreme Court said that it was just fine because of what they had said in Kansas, which was a 5-4 decision. And they relied on the Washington Supreme Court saying that the law was civil in a 6-3 decision. I think the U.S. Supreme Court really misunderstood what the case was about, and I'll talk a little bit about that here. They said that Mr. Young could not obtain release with an as-applied challenge to the Washington law. That in effect, the Washington Supreme Court had said it was a civil case, and so we can't come in and say, well, he's being treated badly, because the treatment of one person, according to the U.S. Supreme Court, isn't going to invalidate the statute. And because confinement goes over time, it can't be an as-applied challenge. It has to be what's going on for the system as a whole. And they disagreed with Justice Stevens because the Ninth Circuit had said the law was civil. The Washington Supreme Court said it was civil. And so we didn't get to argue, or we didn't get to prevail on the as-applied challenge. It's unfair as applied to Mr. Young. And they said the Ninth Circuit was fundamentally flawed in using an as-applied to Mr. Young analysis. And they said, but don't worry, because we know that the Washington law says that you have the right to adequate care and individualized treatment. And if it's not happening, well, you can always sue. And as a matter of fact, we see that you are already suing. And we did have a 1983 action in federal court in Washington. And there was an injunction to the state that they had to adopt and implement a plan for training and hiring competent therapists. It was really a disgrace, the way the state implemented this flaw and the failure to provide real treatment for many, many years. And the U.S. Supreme Court noted that there's a special master in federal court bringing the center into compliance. The district court had noted some progress. They hadn't met the requirements. There was some progress. So, leave us alone. And so this language is what really surprised me, because nobody had said anything about a first instance challenge. Nobody knew what a first instance challenge was. But the court said, we're not going to consider how the civil nature of a confinement scheme relates to due process challenges, or to the extent to which a court may look at actual conditions of confinement and implementation of the statute to determine in the first instance whether confinement scheme is civil in nature. Well, this was the first instance. This was the very first case. It was the very first case to go to the Washington Supreme Court. It was the very first case to go to the U.S. Supreme Court about this law. So it was the first instance, but they were saying, you didn't raise it in the first instance, and we're not going to address it because this somehow wasn't the first instance. Justice Scalia said that conditions are irrelevant unless the state court has interpreted the act as permitting those conditions, which of course the legislature didn't say you can pretend to have treatment and lock people in prison. They didn't say that. And of course, Justice Stevens says you have to consider conditions to understand the full effects of the statute. Supreme Court majority said we've not squarely addressed the relevance in the first instance. We're not going to resolve it here. It cannot be deemed punitive as applied to a single person in violation of double jeopardy and ex post facto. And so we're going to reverse it. We thought we were in the first instance arguing due process, but they didn't think so. So Justice Stevens says the conditions of confinement are evidence of the purpose and effect of the statute, and it was punitive in its purpose and effect if Mr. Young can prove everything he says about the punitive nature of the prison that he's being held in and the lack of treatment. So Justice Stevens says, okay, the majority says that confinement is not a fixed event, so you shouldn't consider it, except in the first challenge to a statute, when as a practical matter, the evidence of such conditions is most likely not to constitute clearest proof because they just began it. We, of course, had already developed lots of evidence about the lack of treatment and the punitive nature of the confinement, and that in many ways, Mr. Young had less privileges than had he been a prisoner in the regular prison wing. And we thought we were in the first instance when nobody even knew what the first instance meant before this. And so Justice Stevens says, if the conditions are such that the detainee has been punished twice in violation of double jeopardy, it's irrelevant that the scheme has been previously labeled civil without full knowledge of the effects of the statute. In other words, the Washington Supreme Court said the statute was civil because before they had full knowledge of the effects of the statute and the punitive nature of the facility and the way they were being treated. And so Justice Stevens said, it is very relevant what's going on, and we should consider it. And the detailed allegations about the absence of treatment for his alleged mental illness and the starkly punitive character of the conditions of his confinement, if proved, then they're getting worse treatment than if they were criminal prisoners. And the law should be characterized as criminal. And so Mr. Young should be given the opportunity, as the Ninth Circuit said he should have, to come forward with the clearest proof that his allegations are true. That never happened because the Ninth Circuit sent it back to district court, and we got nowhere in district court. And the Ninth Circuit said, you know, the statute's civil, and you don't get to argue that anymore, and we think it's civil, so go away. A couple of years later, Mr. Young went back to the Washington Court of Appeals. His case had been stayed because of other cases that were pending concerning the condition of confinement issues. He had a couple annual reviews during that time. There were a lot of issues raised. The court affirmed the lower courts and gave him no relief. But after 20 years, literally being locked up in prison in the so-called predator treatment program. He was released finally in 2010 at the age of 69 to live quietly in Tacoma. I thought I would review this little chart that was made by King TV because it really addresses what both the Washington Supreme Court and the U.S. Supreme Court just were not willing to look at. In 1994, the federal Judge Dwyer, may he rest in peace, ruled the Special Commitment Center was too much like a prison, and he fined the state $11 million. The fine was later dismissed. This case went on and on and on. In 1999, the state was found in contempt of court because they didn't do some of the things the court had ordered them to do. In 2004, the state spent $61 million to build a facility on McNeil Island for civilly committed sex offenders. Before that, they'd been held in Monroe and then in a prison on McNeil Island. We were in the U.S. Supreme Court in 2000. So it wasn't until 2004 that they built a facility to so-called treat, and they spent an unbelievable amount of money. 2005, they opened halfway houses for residents who could live in the community, but one of them was on McNeil Island. And of course, you have to get a ferry boat to get off of the island. And it wasn't until 2006 that the first resident moved into one in Seattle. In 2007, Judge Martinez lifted the injunction that Judge Dwyer had imposed 13 years earlier. So it took 13 years for the state to overcome the deficiencies. And all that time, people were locked up. So I was asked to address how all this relates to the change in sentencing in Washington for sex offenders. It used to be, when I started practicing, everybody had indeterminate sentences. So you'd be sentenced to prison for the maximum term, and the parole board would decide when you get out. Then in 1984, we had the Sentencing Reform Act, which required presumptive and determinate sentences. So the judge would say, you got 48 months. And the parole board was going to go out of business, but the legislature decided, you know, we're not so sure about the sex predator law, how it's going, and we want to do more control of what happens to sex offenders. So we're going to change the parole board to the Indeterminate Sentence Review Board, and we're going to make some sex offenders, most of them, subject to it. And so the court shall impose a maximum term and a minimum term. So we went back to what we had done before 1984 for sex offenders. And so they then get a maximum term, which is the maximum statutory punishment. And then the ISRB decides when they can go home. So before that, before this change in the law, the ISRB was pretty much just dealing with people who had been sentenced. Everybody after 84 had a determinate sentence. Excuse me. And so the ISRB has three types of cases: people before 1984, sex offenses, and then these youthful offenders that the U.S. Supreme Court cases and Washington Supreme Court cases have allowed to have new review. So they review cases, conduct hearings. If somebody gets out on parole and then they have a violation of their conditions, and there's a hearing about that. And so that's what, and the way the ISRB in its annual report describes their board, they say they were revitalized when the legislature passed this new law about sex offenders. bringing those cases under the jurisdiction of the ISRB. And according to the ISRB, what this does is provide consistency in sentencing, combined with a mechanism to address cases where likelihood of sexual recidivism was high. The new model provided for ongoing community supervision for people that are allowed out, and the ability to add conditions in addition to those imposed by the court at sentencing. So if the parole board says, well, we can let you out, but only, the ISRB, we can let you out, but only under these 3 conditions, which the sentencing judge never thought about, they can add that on. Whether that's good or bad, I leave for other people to determine. So the history of this law raises really disturbing questions about fairness, allocation of resources, the distortion of mental health treatment. In one of the cases, the state presented to the judge at the beginning of the case a report that the psychologist had done for the state. This was a psychologist who was hired by the state. He had never met the client. At the very same time, the client had been getting treatment and evaluation by a psychologist in the prison who was asked by the prosecutor, is this client a sexually violent predator? And the answer was no. Well, when the prosecutor presented the case to get the client arrested under this new law, the so-called predator law, the prosecutor gave this hired consultant who never met the client, gave his opinion to the judge, but did not give the prison psychologist's opinion to the judge, who said that the client was not a predator. That's the kind of unfairness and distortion of facts that this law was built on in its initial several years of implementation. And it's really a dark side, I believe, in our state's treatment of folks under the fear that someone's going to commit a crime in the future when they've already been punished in prison, they haven't done anything wrong in prison, and they have a plan to live their life when they get out. It's just it's really an unfortunate chapter in our state's history. I wish I could take questions, but this is a recording, so I cannot. But thank you very much. I appreciate the opportunity to talk with you about this law and how it came about. I understand that one of my colleagues is going to be speaking to you about what's been happening in the past few years with this law, and look forward to hearing about that. Thank you again.